see. So all in all, this law has reflected broad-based consensus. It has reflected the view, the aspirations of the entire Chinese nation, including our compatriots in Hong Kong. And in terms of the process of legislation, it is in full compliance with the legislative procedure in China. Let me also say that this new law has been added to the list of the Annex 3 of the Basic Law. This is also based on the relevant provisions of the Basic Law and the Constitution. And before the decision was made, it was required that the views from the NPC's Committee of the Basic Law of Hong Kong SAR and the views of Hong Kong SAR government shall be solicited. This is also an important aspect of or channel of listening to the views and opinions from Hong Kong society. And certainly we have done this in a fairly short period of time. And it was yesterday on the 30th of June that the legislation was completed and law was added to the Annex 3 of the Basic Law. The message is everything is in keeping with the legal procedure. TAS. Recently, some Western countries have issued the statement saying that this national security legislation for Hong Kong is against one country, two systems. What is your take? Those countries also threaten that if this law is passed, China will be subject to sanctions. What is your response? The first thing I want to say that this national security law is completely in keeping with the one country, two systems. It is a perfect combination of adhering to the one country prerequisite and respecting the differences between the two systems. It is a perfect combination. The law is established to uphold the one country, two systems. It doesn't overstep the framework of the one country, two systems. Its impact is also clear. It will contribute to the stable and long-term implementation of the one country, two systems. Some of the recent happenings in Hong Kong reflect a deviation from the right track of one country, two systems, even to the extent of challenging the policy of one country, two systems. And this new law, to some extent, is to pull things back to the right track. And ultimately, the purpose, the goal is to uphold and advance the cause of one country, two systems, instead of changing the practice. I have noticed that in recent days, some political figures of some countries are making unwarranted accusations against us. They say that China is to seek one country, one system. But if we were to seek one country, one system, things would have been much simpler. We could have applied China's criminal law, criminal procedure law, and national security law directly in Hong Kong. And why would we bother so much to make a special law particularly and solely for the Hong Kong SAR? I think a key question here is whether one understands the one country, two systems fully and faithfully. The central government has repeatedly stressed the importance of fully and faithfully understanding and implementing the one country, two systems. This is because some in Hong Kong and somewhere else in the world, they're using one country, two systems for ill motives. Every time when the central government exercises some legitimate and lawful power, some Western politicians are always so eager to make unwarranted accusations with their misrepresentation of the one country, two systems and the high degree of autonomy. In their view, the central government of China must keep out of Hong Kong's affairs, and they themselves can point fingers. But how is that possible for the central government to sit and do nothing when a few anti-China elements are going all out to stir up riot in Hong Kong, split the country, and jeopardize China's national security? Is there any country in the world that will permit such offenses happening time and again on its own soil? The one country, two systems is our state policy. No one understands better than us the true essence of the one country, two systems. No one cares more than us about the one country, two systems. We are in the best position to define and interpret the one country, two systems. As you mentioned in your question, that some countries are threatening us with sanctions, I would say this is the logic of bandits. What we have formulated is a law for safeguarding national security in an administrative region of China. This is purely China's domestic affairs. There is no logic supporting those threats of sanctions. We didn't provoke anyone. It reminds me of two phrases in Hong Kong dialect, meaning, you know what you are doing. There is none of your business. I must say that we Chinese will not be scared by anyone. Long gone are the days when we Chinese had to take cues from others. This is my answer to your question.
With Xintao Daily, the Hong Kong society is watching closely the law enforcement power and jurisdiction over relevant cases. My question is the Office for Safeguarding National Security of the Central People's Government in Hong Kong, an office set up by central government departments according to Article 22 of the Basic Law and according to Article 60 of the national security law, the acts performed in the course according to Article 60 of the Law on Safeguarding National Security in Hong Kong, the acts performed in the course of duty by the Office for Safeguarding National Security in Hong Kong shall not be subject to the jurisdiction of the Hong Kong SAR. What does this mean? With the implementation of this law, how will the office perform its duties? Will it send the suspects for trial on the mainland? Will the law on safeguarding national security in Hong Kong apply, or will the law on the mainland apply? Thank you for your question. The central government has the power and the responsibility to take all necessary measures to safeguard national security, including in formulating laws, setting up jurisdictions, and improving mechanisms. This is the basis for us to consider how to handle some specific matters. According to the law on safeguarding national security in Hong Kong, the Central People's Government set up an office for safeguarding national security in Hong Kong. This office is established based on the NPC's decision last month, as well as the just adopted law on safeguarding national security in Hong Kong. From the name, one can tell that this office is established by the Central People's Government. It is different from the offices set up by central government departments or set up by provinces, autonomous regions, or municipalities in Hong Kong in accordance with Article 22 of the Basic Law, as you mentioned. According to Article 60 of the Law on Safeguarding National Security in Hong Kong, the acts performed in the course of duty by the Office for Safeguarding National Security in Hong Kong and its staff shall not be subject to the jurisdiction of the Hong Kong SAR. This means that the acts of the office and its staff in the course of duty shall not be subject to the jurisdiction of the executive authorities, legislature, and judiciary of Hong Kong. This is important to ensuring the performance of mandate by the office, because the office exercises its jurisdiction with a mandate that goes beyond the high degree of autonomy enjoyed by Hong Kong, and relevant affairs to be handled by the office also involve state secrets. So it is solidly based on both law and practice to state that the acts performed by the office will not be subject to the jurisdiction of Hong Kong SAR. In formulating Article 60, we also refer to relevant provisions of the garrison law and the common practices of other countries. In Hong Kong, we have the Office of the Central People's Government in Hong Kong. We also have the Office of the Commissioner of the Foreign Ministry in Hong Kong. And we also have the garrison in Hong Kong. And now, with the establishment of the Office for Safeguarding National Security of the Central People's Government in Hong Kong, we now have 4 bodies set up by the central government in Hong Kong. And in the U.S., it has 2 judicial systems at the federal and at the state level. And the state exercises jurisdiction over some matters. But this does not mean that the Office for Safeguarding National Security in Hong Kong is subject to no one's jurisdiction. The law on safeguarding national security in Hong Kong has strict provisions on the enforcement procedures and supervision mechanisms of the Office for Safeguarding National Security in Hong Kong. It raised multiple questions, actually 4 or 5 of them. One question concerns the law enforcement of the office. Let me say this. It is made clear in Article 55 of the Law on Safeguarding National Security in Hong Kong that the Office for Safeguarding National Security in Hong Kong only exercises jurisdiction on 3 specific occasions. The office may take the form of initiating investigation into the cases. They may arrest suspects upon the approval of designated procuratorate. And in terms of other follow-up measures, for example, prosecution, trial, and other matters, it was stated clearly in this law, that is, the People's Procuratorate, designated by the Supreme People's Procuratorate, would prosecute the cases, and the courts designated by the Supreme People's Court will handle the cases. The arrangement is made because the legal system on the mainland is different from that in Hong Kong. Relevant law enforcement and judicial authorities at the state level are different from those in Hong Kong. They should and must perform their duties in accordance with their respective laws. It is impossible to ask Hong Kong police or prosecutors of the Department of Justice to enforce laws of the mainland or vice versa. That won't work, because that would easily create problems related to jurisdiction and application of law. According to the law on safeguarding national security in Hong Kong, the law enforcement and judicial authorities at the state level and in Hong Kong will exercise whole process jurisdiction respectively, including investigation, prosecution, trial, and imposition of penalty. So in this way, there will be whole process jurisdiction respectively for the authorities at the state level and in Hong Kong. In this way, relevant authorities can have clearly defined duties and jurisdictions. They can also complement each other, coordinate with each other, and support each other. In this way, they can jointly form the system and mechanisms for safeguarding national security in Hong Kong. This is my answer. Thank you. Thank you. With Guangming Daily, we know that the name of this law is the Law of the People's Republic of China on safeguarding national security in the Hong Kong Special Administrative Region. The content of the law is not limited to the Hong Kong SAR. My question is, what is the meaning of safeguarding national security in Hong Kong? The important expression, safeguarding national security in Hong Kong, is the key word. At the 4th plenary session of the 19th CPC Central Committee, it was made clear that it is important to establish and improve the legal system and enforcement mechanisms for safeguarding national security in the SARs. Later, the focus has been placed on Hong Kong. This year, at the 3rd session of the 13th NPC, a decision was adopted. The name of it is on establishing and improving the legal system and enforcement mechanisms for safeguarding national security in Hong Kong. So in this way, it is clearly proposed that relevant work will be advanced at the state level. The just adopted law on safeguarding national security in Hong Kong, as you mentioned, goes beyond the Hong Kong SAR itself in terms of the content of the law. So the expression safeguarding national security in Hong Kong is very important to understand its meaning, and it at least carries 3 layers of meanings. Number 1, the work and activities for safeguarding national security by the Hong Kong SAR itself. This is clearly stated in the decision and in the just passed law. The executive authorities, legislature, and judiciary of the Hong Kong SAR shall effectively perform their duty for safeguarding national security in accordance with this law and other laws. This is the first layer of the meaning of the expression, that is, the duty to be assumed by the Hong Kong SAR itself. It must take the primary responsibility in this regard. Number 2, the work and activities for safeguarding national security within the Hong Kong SAR. Just now, Mr. Zhang mentioned that the Central People's Government shall establish in the Hong Kong SAR an Office for Safeguarding National Security, and the name of the office is the Office for Safeguarding National Security of the Central People's Government in Hong Kong. And other offices set up by the Central People's Government also in Hong Kong also carries responsibility for safeguarding national security. So together with those offices, this new office will also perform its mandate for safeguarding national security in Hong Kong. And the third layer of the meaning is that the work and activities for safeguarding national security relating to the Hong Kong SAR. The Central People's Government has an overarching responsibility for national security affairs relating to Hong Kong. Overarching responsibility means the ultimate responsibility or the comprehensive responsibility. So this layer of meaning goes beyond the previous 2 layers of meanings, and relevant activities and work is very important. The central authorities and the Central People's Government has an overarching responsibility for national security affairs relating to Hong Kong. So these are the 3 layers of meanings of the expression safeguarding national security in Hong Kong. In the 6 chapters of the law, there are very clear provisions. For example, in Chapter 2, it clearly states the duty and government bodies of the SAR, and in Chapter 5, the Office for Safeguarding National Security in Hong Kong shall be established. So generally speaking, the expression carries broad meaning. This is my answer to your question. Thank you.
First of all, let me clarify that in Article 29 of this law just passed, collusion with a foreign country or with external elements to endanger national security is different from common external connections and exchanges. Common, normal external connections and exchanges are not a crime by no means, because some in Hong Kong don't understand what the word collusion means. Well, collusion is a concept used in the criminal law of the PRC, and there are similar provisions in the criminal laws of other countries. Well, the word collusion means to work together to do something bad. It is indeed a negative word. And in the criminal law, collusion is not about doing some petty bad things. It is about doing criminal acts. In Article 29 of the National Security Law for Hong Kong, the main manifestations of collusions are clearly stipulated, which define what acts may constitute a crime. And there are specific stipulations. And I have the text with me, and I think it is very clearly written. So Article 29 specifies the following scenarios. The first is to steal, spy, obtain with payment, or unlawfully provide state secrets or intelligence concerning national security for a foreign country or an institution, organization, or individual outside the mainland, Hong Kong, and Macau of the People's Republic of China. That is what we usually call espionage. The second is to request, to conspire with, or to directly or indirectly receive instructions, control, funding, or other kinds of support from a foreign country or an institution, organization, or individual outside the mainland, Hong Kong, and Macau of the People's Republic of China, to commit criminal acts. So the external elements is a must in this. But here what we say is that there are other elements are needed to constitute such an offense. For example, a criminal intent to endanger national security. For example, through such collusion, one has to commit criminal acts specified in the article in the national security law. So it has to be linked with those acts. And you also mentioned, the journalist mentioned, the meaning of inciting hatred. First of all, I want to say that inciting hatred as an offense is something we copied from legislation of Hong Kong. In the laws in force of the Hong Kong SAR, there is a crimes ordinance. In Article 9, it is mentioned hatred, inciting hatred towards people and government may constitute an offense, which shows that in formulating this new law, we have given full consideration to the existing provisions and laws of Hong Kong and the concepts, practices of the common law system of Hong Kong. Normal day-to-day acts of hatred will not constitute an offense, because it is clearly specified in the law that it will have to there is another condition, that is, it may cause severe consequences for it to constitute an offense. If someone spreads rumors to incite hatred in society towards the central government, for example, there was a rumor last year that there were homicide in Hong Kong, and direct the attention to the Hong Kong police, and it was clearly made up. It is possible that this rumor was targeted at the central government and it has caused serious consequences, and that act may constitute such an offense. Give another example. Last year, we saw people going to another country and beg these countries to sanction China. If serious consequences were caused, it is also punishable by this law. Thank you. Next question, please. Thank you. China Daily. Article 23 of the Hong Kong Basic Law says that the Hong Kong SAR shall enact laws on its own to prohibit any act or activity endangering national security. My question is, now that the NPC Standing Committee has enacted this new law, does Hong Kong still need to enact the Article 23 legislation? What is the relationship between the Article 23 legislation, the law adopted by the NPC Standing Committee yesterday, and the current laws of Hong Kong? In the Basic Law of Hong Kong, there is an Article 23. I think this article is best known in the provisions of the Basic Law both in Hong Kong and in the mainland. The National People's Congress has made the decision, and the NPC Standing Committee has formulated this new law for safeguarding national security in Hong Kong, and people are paying a lot of attention to the Article 23 legislation. In the process of making the decision and formulating the new law for safeguarding national security in Hong Kong, this question has been given careful consideration. At the third plenary session of the 13th National People's Congress, the NPC adopted the decision to establish and improve the legal framework and enforcement mechanisms for safeguarding national security in Hong Kong. In Article 7 of the new law, it is also clearly stipulated that Hong Kong SAR must complete as early as possible the legislation for safeguarding national security as stipulated in the Basic Law and refine relevant laws. Just now, Mr. Zhang mentioned that we have waited for 23 long years for that to happen, and the coincidence of the many 23s. It is stipulated that Hong Kong SAR must complete this legislation. This is clearly provided for in the law. The Hong Kong SAR, the chief executive and the government have also made their attitude clear that after the adoption of this new law, they will refine relevant laws of the Hong Kong SAR in this process. To be more specific, I want to talk about something that many people in Hong Kong and across the country are very interested in. First is, what is Article 23? Well, it asks the Hong Kong SAR to enact national security legislation on its own, and it lists 7 types of acts and activities endangering national security that must be prohibited. For example, secession, subversion, inciting rebellion, treason, theft of state secrets, and there are other 2 acts that are related to political organizations or bodies from foreign countries. Altogether, there are 7 types of acts and activities that must be prohibited and punished. That is the requirement of Article 23 of the Basic Law. The MPC decision contains an Article 6, which authorizes the MPC Standing Committee to formulate a law for safeguarding national security in Hong Kong to effectively prevent, suppress, and impose punishment for 4 types of offenses endangering national security. And they are secession, subversion, organization and perpetration of terrorist activities, and collusion with a foreign country or external elements to endanger national security. These 4 types of offenses were clearly set out in the law. And between the Article 23 of the Basic Law and the new law just passed, there is an overlap, that is secession and subversion. Subversion of state power as defined in the new law and subversion of the state government as stated in the Basic Law. Second, the Article 23 and this new law are also quite different, you can tell from the texts published. This new law for safeguarding national security in Hong Kong specifies the 4 types of offenses endangering national security. In addition to that, it also includes other important provisions. It is mentioned just now that it is a law integrating substantive law, procedural law, and organization law. Its contents include 2 levels: institutional arrangements and design at the Hong Kong SAR level and institutional design at the state level. And it consists of 2 aspects. One is to improve the legal framework for safeguarding national security, and the other is to improve the enforcement mechanisms, legal framework and enforcement mechanisms. And third, it integrates substantive law, procedural law, and organization law, which means this new law is much broader than what is specified in the Basic Law in terms of Article 23. Third, this new law does not replace the Article 23 legislation of Hong Kong. So the government of the Hong Kong SAR's duty to enact its own legislation for safeguarding national security is not replaced by this new law for safeguarding national security in Hong Kong adopted by the NPC Standing Committee. Fourth, the Hong Kong government's duties in terms of completing the legislation for safeguarding national security, and also to refine relevant laws, which means the Hong Kong SAR needs to not only pass the Article 23 legislation, but also others. So it is not limited to the Article 23 legislation. Just now it is mentioned that last year in the Hong Kong SAR there was a case according to the Societies Ordinance currently in force in Hong Kong, and also the Crimes Ordinance in Hong Kong, and other Official Secrets Ordinance and other local laws relating to national security. So the SAR needs to refine its relevant laws in addition to formulating the legislation required by Article 23 of the Basic Law. Finally, there is another important point, that is Hong Kong's own national security legislation and their implementation shall not contravene the NPC decision and the law on safeguarding national security in Hong Kong adopted recently yesterday by the NPC Standing Committee. It shall not contravene the decision and law adopted at the state level. These are very important institutional design. At the third plenary session of the 13th National People's Congress and the 20th and 19th session of the NPC Standing Committee, it is also clearly stated this new law is in line with the Constitution, the Basic Law of Hong Kong, and the spirit of the NPC decision. This is a very important institutional arrangement, and I am sure it will be implemented effectively. Thank you. Next question, please.
Ta Kung Wen-hui Pao of Hong Kong. It is said in this new law that a resident of the region who stands for election or assumes public office shall confirm in writing or take an oath to uphold the basic law of the Hong Kong SAR of the People's Republic of China and swear allegiance to the Hong Kong SAR of the People's Republic of China. A person convicted of an offense endangering national security by a court shall be disqualified from standing as a candidate in the elections of the Legislative Council and District Councils or holding any public office in the region. Is this to disqualify some opposition candidates in the September election of the Legislative Council to swear allegiance to the Hong Kong SAR? Does this mean also to swear allegiance to the People's Republic of China? Well, Article 6 of this new law provides stipulations with regarding to the oath-taking and allegiance swearing for people holding public offices. And this provision has taken reference from the Article 104 of the Basic Law, but the scope of application is wider than the Basic Law. It goes beyond the scope as defined in the Basic Law, such as Chief Executive and President of the Legislative Council. The new law will involve anyone who is to assume public office. In the meantime, there is also a provision that a resident of the region who stands for election or assumes public office shall confirm in writing or take an oath to uphold the Basic Law and swear allegiance to the Hong Kong SAR of the People's Republic of China. As a matter of fact, since 2016, similar practices have already been adopted by the SAR government for anyone who is to run for a position in the Legislative Council or in District Council. You would have to sign a relevant confirmation letter. So this new law has legalized this practice. It has met the needs on the ground. It is well justified and lawful. Let me also say that whether it is the Article 6 of this new law or whether it is Article 104 in the Basic Law, the provision of swearing allegiance to the Hong Kong SAR undoubtedly includes allegiance to the country, namely the People's Republic of China. This is quite obvious. This is determined by the legal status of the Hong Kong SAR. The region is an inalienable part of China. It is a special administrative region with a high degree of autonomy. So for people holding public offices, when they swear allegiance, certainly they are swearing allegiance to the country. One should not take an out-of-context view on this matter. One should not erroneously think that allegiance to Hong Kong SAR is only to the SAR. I say this with good reason, because some people in Hong Kong do hold this wrong view. In addition, in the National People's Congress Standing Committee's interpretation of the Article 104 of the Basic Law in November 2016, it is also stipulated that the taking of oaths stipulated by Article 104 of the Basic Law is a legal pledge made by public officers specified in the article to the People's Republic of China and its Hong Kong SAR, and is legally binding. You mentioned whether this is the purpose of having this stipulation in the new law, whether it is to disqualify some people in the September election in the Legislative Council. Well, I would like to say that those who hold this view think that we are as narrow-minded as they are. The Central People's Government has decided to formulate this piece of law. The purpose is to safeguard national security. It is to safeguard the national security and restore stability in Hong Kong. It is to promote long-term implementation of the one country, two systems. So we are on a much higher ground. We are looking at a much broader horizon. And you also mentioned if those opposition candidates may get disqualified because of opposing this law. I think this could be a question worth of studying, but I believe in the near future, the SAR government will make specific definitions or regulations based on the basic law, this new national security law, and the existing laws and regulations in Hong Kong SAR. Another point I want to stress here is that this legislation, its purpose is not to take the pro-democracy camp in Hong Kong as an imaginary enemy. This is not the purpose of the legislation. The legislation is focusing on combating a narrow category of crimes against the national security. The local society of Hong Kong is diverse. The local politics is diverse. The one country, two systems has already spoken volumes of the political tolerance of the Central People's Government. So the various parties, including people with different political views, different positions, they will continue to exist for a long time in Hong Kong. As Comrade Deng Xiaoping once said, the opposition, you can say bad things or criticize the Communist Party of China, but you should not use this as a pretext to do things against China, against our national security, and use this as a pretext to turn Hong Kong into a safe haven of anti-China forces. We are adopting one country, two systems. We have the socialist system, and we understand that the capitalist system has its own rules of politics, but there are always some red lines. There are always some basic principles, and these basic principles shall not be breached. This is true in any society. So the oppositions in Hong Kong, I hope they could do some self-reflection and do some self-adjustment. Xinhua News Agency. This law on safeguarding national security in the Hong Kong SAR says that the central government can exercise jurisdiction on 4 categories of offenses against national security. What will be the principles followed by the central government in exercising the jurisdiction, and what will be the division of responsibility as to the jurisdiction of the cases between the central government and the Hong Kong SAR? This is an important question. As we said earlier, that according to Article 55 of this new law, there are some certain circumstances when the central government can exercise jurisdiction on certain cases. But to begin with, the law says clearly that the Hong Kong SAR has the constitutional responsibility for safeguarding national security. The Article 12 of the new law requires that the SAR government shall establish a committee for safeguarding national security, and the committee shall be responsible for affairs relating to and assume primary responsibility for safeguarding national security in the region. It also says that the committee shall be under the supervision of and accountable to the Central People's Government. So this is the general principle. And when it comes down to the specific jurisdiction of individual cases, then again, this principle, this guideline will be followed. As you can see in Article 40, it says explicitly that the Hong Kong SAR shall have jurisdiction over cases concerning offences under this law, except under the circumstances specified in Article 55 of this law. And then certainly you will turn the page to Article 55. The Article 55 specifies the certain circumstances that the Office for Safeguarding National Security of the Central People's Government in Hong Kong SAR to exercise jurisdiction over certain cases. And the cases shall be as follows. First, the case is complex due to the involvement of a foreign country or external elements, thus making it difficult for the region to exercise jurisdiction over the case. So this is the scenario 1. And scenario 2. A serious situation occurs when the government of the region is unable to effectively enforce this law. So this is the second type of scenario. There is a serious situation and the government of the SAR is unable to effectively implement this law. And scenario 3 is that a major and imminent threat to national security has occurred. So these are the 3 circumstances under which the office is to exercise jurisdiction. So you can see that these circumstances are specified, and to be honest, we don't hope to see any of them. Certainly we don't want to see a serious situation or a major or imminent threat to national security. But since it is about designing a legal system, we have to take into account all types of eventualities. And procedure-wise, when the Office for Safeguarding National Security of the Central People's Government in Hong Kong SAR is to launch jurisdiction, then there are strict steps to follow. Specifically, it requires the SAR government or the office itself to make the proposal, and in whichever case, it needs to have the approval from the Central People's Government. And following this procedure, and also under the above-mentioned 3 circumstances, can there be the exercise of the jurisdiction over the cases in question by the central government. And when the office is to exercise jurisdiction over some cases, the whole process is an interconnected one that involves many links. For instance, the office shall initiate the investigation into the case, and the Supreme People's Procuratorate shall designate a prosecuting body to prosecute it, and the Supreme People's Court shall designate a court to adjudicate it. And when it comes to procedural matters like criminal investigation, examination and prosecution, trial, and if necessary, the execution of penalty. For these procedural matters, the criminal procedure law of the People's Republic of China and other related national laws will be applied. So this is what is about Article 56, 55, 56, and 57 in this new law. This is a whole complete set of provisions. I also want to say that the Office for Safeguarding National Security and other relevant agencies of the country exercise jurisdiction only on a very small number of offenses that seriously jeopardize national security. Although it will involve or concern only a very small number of people, we have to include this scenario or this arrangement in designing a legal system. The new law has also fully reflected the overall governing power of the Central People's Government. It will help support and strengthen the law enforcement and judicial work of the Hong Kong SAR in safeguarding national security. It will contribute to preventing the scenarios that are likely to trigger the state of emergency as specified in paragraph 4 of Article 18 of the Basic Law. Once such state of emergency occurs, it is indeed very serious situation. You can check about this in Article 18 of the Basic Law of the Hong Kong SAR. And in this national security law, the related provisions, as I mentioned in my answer to your question, can actually help forestall such scenarios. In other words, we are using an ongoing but low-intensity approach to safeguard national security in Hong Kong. We prevent, we forestall, we implement precautions against those likely serious scenarios. So this is an important point I wish to make.
With the times, what measures will be taken in this new law to ensure the judicial independence of Hong Kong? And if the chief executive can designate judges, does this contradict the spirit of judicial independence? Thank you. Well, this is a question about judicial independence. According to China's constitution, the People's Court and the People's Procuratorate can exercise their functions and duties independently, free from interference. This is clearly stipulated in the Constitution and relevant laws. In the Basic Law of Hong Kong, there are also very clear provisions on this point. Some people are watching closely judicial independence, and it is stated in Article 88 of the Basic Law that the courts in Hong Kong can try cases independently, free from interference, and their duties will not be held to account in the course of the performance of their duties. And the Basic Law also has very clear provisions on prosecution. In Article 63, it was stated that the Department of Justice undertake relevant responsibilities of prosecution free from interference. So as I mentioned in the Constitution, the Basic Law, and the other relevant laws, it is clearly stipulated that judicial independence will be upheld, and judicial independence has been ensured in accordance with relevant laws. It was mentioned that concerning the judges that will try the cases concerning offense endangering national security, we have made some rules in this new law. That is, the chief executive shall designate some judges from the magistrates, from the judges of the district court, the judges of the court of first instance, and the Court of Appeal of the High Court, and the judges of the Court of Final Appeal. And such designated judges will be responsible for trying cases concerning offense endangering national security. And you can find relevant provisions in Article 44. So this article is very important to ensure that relevant judges can try cases effectively, and this article will not affect the performance of duties of the judges at large. The system of designated judges has the following meanings. Number one, the chief executive shall designate a group or a number of judges from incumbent judges. Number two, the designated judges shall be responsible for trying cases concerning offense endangering national security, and for other judges that do not serve as designated judges, they can continue to perform their duties and try other types of cases. Actually, a broad range of cases can be tried by these other judges that are not designated judges. And number three, there is the scope of designation. The judges may come from magistrates, the judges of the district court, the court of first instance, and the court of appeal of the high court, and the court of final appeal. So there is a sort of name list of judges that can be designated. And number four, it is clearly stipulated that when designating the judges, the chief executive, may consult the Committee for Safeguarding National Security of the Hong Kong SAR and the Chief Justice of the Court of Final Appeal. This is also a very important way to ensure the effective arrangement of the system. And number 5, as I mentioned, there is this principle of independent justice or judicial justice. Relevant cases will be tried free from interference. So in this sense, the institutional arrangement reflects the primary responsibility assumed by the Committee for Safeguarding National Security in Hong Kong SAR. Meanwhile, we have also considered the actual situation of the judges in Hong Kong. As such institutional arrangement can help make the adjudication of cases more efficient. And the designated judges may be more experienced and more professional in trying the cases concerning offense endangering national security, and with a certain name list of designated judges, they can apply consistent standards in trying relevant cases. Just now we mentioned the offense of collusion in Article 29. Relevant cases have their own characteristics, so the designated judges, if they are familiar with relevant cases, they can try the cases more effectively. An example I want to use here is secession or subversion. Such cases would not produce a real effect, because if the country would be seceded or subverted, then what kind of crime would be prosecuted? So this is the feature of this kind of crime. The state power of the People's Republic of China, be it at the state level or at the Hong Kong SAR level, the whole country, the whole state, will never tolerate any acts of secession or subversion. So this is the feature of this kind of offenses. We can never allow such cases to produce an effect. So how to identify the elements of the crimes? This requires analysis based on the characteristics of these offenses. So if we have some designated judges who are more familiar with the situation, the conditions, the elements, then they can try the cases more effectively. This is my answer to your question. Thank you. With CGTN, according to Article 66, this law shall come into force on the date of its promulgation. Does this mean that offenses endangering national security which occurred before the promulgation of this law will not be investigated or prosecuted? Thank you. Well, in terms of retroactivity, this law is consistent with the general principle of laws in force in the world. It doesn't have retroactive effect. This is very clear. This shows that this new law follows the modern principles of law. Meanwhile, let me point out that the laws in force in Hong Kong, including, as I mentioned, the Crimes Ordinance, the Societies Ordinance, Public Order Ordinance, and Official Secrets Ordinance. In these laws in force in Hong Kong, they have some provisions related to the acts and activities concerning offences endangering national security, provisions of these laws should be applied to punish acts endangering national security that occurred before the entry into force of this law. According to Article 8 of the new law, it is stipulated that in order to safeguard national security effectively, the law enforcement and judicial authorities of Hong Kong shall fully enforce this law and the laws in force in Hong Kong concerning the prevention of, suppression of, and imposition of punishment for acts and activities endangering national security. This shows that the laws in force can be applied to punish offences endangering national security that happened in the past. The law enforcement and judicial authorities need to take their statutory duty to do this. Surely, apart from punishing crimes, a more important function of criminal law is to prevent crimes. So we sincerely hope that with the implementation of this new law, the Hong Kong society can carefully study and understand this law, have a stronger sense of national identity, national security, and the rule of law. In particular, education at schools and universities should be enhanced in this regard. We hope that the young people in Hong Kong can all be patriotic, love the country, love Hong Kong, abide by the law. We hope that all of them can have a bright future. Thank you.
The conference has lasted for a long time, but still I see many hands. So I suggest we have 2 more questions. First, Phoenix TV. Phoenix TV. This law has taken effect. People are interested in the question that is, while preventing, suppressing, and imposing punishment for acts endangering national security, will this law restrict the rights and freedoms of Hong Kong residents, and will it be in conflict with relevant international covenants and human rights-related laws of Hong Kong? Respecting and protecting human rights. In formulating relevant law, the central government attaches great importance to the protection and respect of human rights, which is a very important principle of law. Not only in the Hong Kong SAR, actually throughout the country, much attention and effort has been given to the promotion of human rights. In the Constitution of China, it is clearly stipulated that the state shall practice law-based governance and respects and protects human rights. In many other laws of this country, criminal law, criminal procedure law, there are similar provisions. This new law, the law on safeguarding national security for Hong Kong, in Hong Kong, has also made it clear, and if you look at the text, such provisions are put in prominent places in the chapter of general principles. It is clearly stated, because the first chapter has a broader significance. The Hong Kong human rights will be protected and safeguarded in safeguarding national security in Hong Kong. It is stipulated in the new law. And when handling these cases, the central authorities must also follow the important principles of law in terms of criminal proceedings. These are all clearly specified in general provisions chapter. For example, the principle of legality, or one shall not be prosecuted or punished if his act does not constitute an offense under the law. That is the principle of legality. And also the presumption of innocence. This is also a very important principle in criminal justice. There are many of them. I will not go into detail. Protection of the right to defend oneself, and other rights in judicial proceedings that a criminal suspect, defendant, and other participants in judicial proceedings are entitled to under the law. It's also provided for in this new law. And no double jeopardy principle is also included in this new law. So no one shall be liable to be tried or punished again for an offense for which he or she has already been finally convicted or acquitted in judicial proceedings. These important principles are provided by the first chapter of this law, and the protection of human rights is not limited to criminal procedure laws. There are also clear provisions that states that the state protects the lawful rights and freedoms the residents of the Hong Kong SAR enjoy under the Basic Law and the two well-known international covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, as applied to Hong Kong. So the rights and freedoms Hong Kong residents enjoy shall be protected in accordance with the law. These provisions of the new law are in line with those in the Basic Law, so it's not limited to criminal procedural matters. Freedom of speech, publication, assembly, and demonstration, these are all the rights and freedoms protected by both the Basic Law and the Law on Safeguarding National Security in the Hong Kong SAR. To safeguard national security, one must punish, in accordance with the law, crimes endangering national security. To effectively prevent and suppress and impose and pursue criminal liability for those acts in accordance with criminal law. So, in this process, many people are concerned about those rights and freedoms. Every right has its clearly defined legal boundary. One country is the bottom line, and the two systems has boundaries. This is what Mr. Zhang just said. If you breach the boundary and the bottom line, that is not okay. Be it in China, in China's Hong Kong SAR, or in any other country in the world. This is the same. You may exercise your rights and freedoms, but that must be done within the confines of law, and one shall not breach the bottom line of law, otherwise there will be consequences according to law. In terms of safeguarding national security, which is a bottom line that no one should cross. The provisions of the International Covenant for Political and Civil Rights, it is also clearly stated that people's freedoms and rights should be protected, but the exercise of such freedoms and rights must be done within the law. And people also may ask, does it mean that you can have random laws arbitrarily formulated? Of course, that is not the case. For example, in terms of national security, public order, public health, and social decency, there are some restrictions, boundaries, or bottom lines that shall not be breached. Absolute rights or freedoms do not exist and are not possible. Well, my colleagues and I that I share the table with are not wearing a mask, but all of you, the journalists, are wearing a mask because you are responsible for safeguarding public health against COVID-19. This is a simple thing, but it's very important. And everyone has the responsibility to follow it. And yet, in some countries, that is not the case. They would say that is a restriction on people's rights and freedoms. All of us have a deep feeling or have a clear understanding of what public health is about through this epidemic. Public order also creates a boundary for those rights and freedoms, and situation may vary in different countries. And just now Mr. Zhang mentioned, for example, in the United States, people have the right to have a gun, but in other countries, it may not be the case. The Civil Code recently introduced at the third plenary session of the 13th MPC in the process of formulating that law, there were calls for recognition in law of same-sex marriage. People may say that in some country or in some places, same-sex marriage is legalized. But coming back to the point I just made, there are boundaries to rights and freedoms wherever you are. And in China's Hong Kong SAR, there are boundaries and bottom lines for the purpose of safeguarding national security. In order to better safeguard national security, human rights must be respected and protected. In order to protect and respect human rights, national security has to be safeguarded. These two are actually serving the same and one purpose. Last question, please. Lianhe Zaobao from Singapore. The U.S. has recently announced several measures to sanction China's push for a national security law in Hong Kong, including visa restrictions on Chinese officials and revoking preferential treatment for Hong Kong. Will China take countermeasures, and what will they be? Some worry that as the sanctions escalate between the United States and China, there might be a financial war, and Hong Kong's status as a financial hub may be weakened in this process. What is China's response to such worries? When answering the question from TASS just now, I already stated my attitude toward foreign sanctions. Some people in the United States have indeed gone too far. if you engage in yet another round of bullying, if they think there isn't enough of a mess domestically, if they just don't care that sanctions actually may bring more loss to them than to the sanctioned, if they want to make this as an opportunity to shift its own crisis and pass the buck, then they can have a try. As it is nothing but an opportunity for us to demonstrate our determination and ability to defend ourselves and fight back. In fact, you may have noticed in recent days, U.S. Secretary of State Mike Pompeo and Secretary of Commerce Wilbur Ross have already announced the so-called sanction measures. The Chinese government has also announced visa restrictions on U.S. personnel who have behaved terribly on Hong Kong-related issues, including entry restrictions and visa restrictions. We Chinese value reciprocity. If the U.S. takes measures, the Chinese government and the government of the Hong Kong SAR will reciprocate. And the countermeasures will come as the situation may call for. The Hong Kong SAR's special economic status, including its standing as a global financial hub, has been earned through decades-long hard work of generation after generations of the Hong Kong people. Such a status is recognized by the world, and also it is underpinned by the Basic Law. It is not something so easily taken away by any country. We have full confidence in maintaining Hong Kong's economic status in the world. We don't have much worries about that, because Hong Kong's status as a global financial hub and its long-term prosperity and stability are mainly dependent on two factors. One is whether or not Hong Kong's comparative advantage built over the years in business environment and financial system will be affected. And the other is whether or not the momentum of the mainland's economic development and the central government's support for Hong Kong will be weakened. Or these two are important factors, and about these two factors we have confidence. That is why we are very optimistic about the future of Hong Kong. This is the